Okay, class. So inshallah today we are now in week 3, which is quarter of our 12 week classes. Okay, the topic for today is intention to create legal relations for our advanced contract law. And this is the third element or the third requirements, or we call it
Sorry, doctor, I need to go to outside. Someone is clicking the bell. I'll just answer and come. Sorry.
okay. No worries, because we
Thank
we
you.
are we
Doctor can proceed first.
okay, we are recording the session, so you can catch up later. Okay. All right. So the topic is intention, as you can see. Okay, to create legal relations, let's see what I have prepared here. So as I said just now, okay, in the previous lectures, in previous two lectures, we have covered offer and acceptance. So now we are fully aware. Okay, we understand that these two, they are very, very important. Okay, the cardinal or the roots, okay, of the contract, essential elements of a contract. But then again, despite the fact that we are able to prove offer and acceptance, okay, in the contract, which are existent, but then it doesn't mean that the parties have a contract already. There are some other things that they have to prove. Okay, so it does not mean that if two parties, offer or offeree, they reach an agreement, and there could be a contract. I mean, there's another thing that we have to consider. Okay, so not all agreements amounts to contract. So the third requirement is we have to see, or the court will ascertain, okay, whether there is any necessary intention of what? To create legal relations. Okay, because sometimes maybe this requirement is missing or lacking or insufficient. So still, even though offer and acceptance are already fulfilled or satisfied, still there could be no enforceable contract. Okay, having said so, the parties came to the contracting parties, offer or offeree, who have reached an agreement. Okay, so both of them must, okay, the word is must, it's not may, must intend legal relations. Okay, for them, okay, what's the benefit? I mean, what's the aim or the purpose here? For them to acquire contractual rights and be bound by contractual duties or obligations. So it works two ways. Okay, I mean, the contract will confer certain rights, and because of that, they are bound by certain contractual obligations. So they must have necessary legal intention, okay, or intention to create legal relations between the two parties here. So that's the introduction for this topic. Okay, let's move further. Okay, all right. So as I said just now, the word is must. Okay, must intend. So both parties, okay, must intend the agreement to be legally binding. I mean, there must be intention on both of them. All right, the question now. I mean, the first question for today, because usually we want to make the session as interactive as possible. So wherever relevant, we'll try to ask for your feedback. Okay, I'll try to throw some of the questions lah. Okay, first question for today. Since Amina is not here, so we are only left with Syarah dengan siapa tadi? Syarah dengan Nurul kan? Alright. Syarah and Nurul. So anyone, how can the court find out what's in the party's mind? Do you think a court, Amina is back. Do you think the court can read whatever things inside the minds of the parties? How? I mean, what can the court do? How? I mean, how to do it? How can the court find out, okay, or determine or figure out whatever in the party's mind? Anyone would like to try? Amina?
By the conduct of the parties.
Okay, looking at the conduct of the parties. How about Shara? Any other ways?
By looking at the
Type of what?
type of the agreement entered between parties.
That type of the agreement. Okay, Nurul? Any other ways or methods? So that the court might ascertain.
Into what do we call that? The procedure in the court? Cross-checking.
But they weren't in the court. I mean, before they go to the court. I mean, whatever happens between them. What are the things that court will look?
Their communication, either by emails or text.
Yeah. So the court might consider lots of things lah, okay, in order to ascertain whether these parties have necessary intention or not. All right. So the nearest, I mean, this is the thing that the court usually do. Okay, the nearest the court can do is in order to figure out or to discover the intention, usually the court will apply objective test lah. The same test or standard test for all most of the situations, okay, to judge the situation what you said just now lah, correct lah, okay, by what was said, whatever thing that they utter, and what was being done, the act lah, their gesture or their conduct, how they react. Okay, including their communications. Okay, this is part of what is being said and done. So the court will judge based on that situation. Because how do we ascertain whatever in your mind kan? Even when they go to the court, maybe they will try to deny kan. So of course the court has to ascertain, do you really have intention or not? Okay, because when you go to the court, you will deny. But from the way you conduct yourself here, from the word, okay, from your words, from your communication, the court might infer, oh, you have the intention to be bound by whatever agreements, okay, that you have entered. Okay, as far as the topic is concerned, this is actually the summary, okay, but we are going to have a detailed discussion on every single rule here, okay. Whatever agreements, okay, under law of contract is possible to divide into two. For the purpose of ascertaining intention, okay. First, we need to ascertain whether is it social or domestic agreements here, okay, or let's say it doesn't fall, or there's nothing to show it. It refers to social and domestic agreements here. Then it means this is something which is under business or commercial agreements. And for each these two groups here, okay, there is a fixed rule, okay, for these two groups here. All right, that's the meaning or the definition of social and domestic agreements. Whatever agreements, okay, whenever it's entered between family members, okay, or even a relative, okay, or even neighbors, workmates, okay, colleagues, okay, as well as friends. So whenever agreement involve these people, okay, so the court actually will consider as it is part of social and domestic agreements. There could be agreements, obviously. They might agree with one another, okay. So what's the rule governing social and domestic agreement here? Okay, the rule is that, okay, the law, there is a certain presumption of law, okay. The law presumes that these parties, okay, do not intend, that's the word do, okay, do not, sorry, bukan do not, okay, no, do not intend to create legal relations. Meaning here, legal relations is missing. Most of the time, they don't want to be legally bound later, okay. So in other words, it means social agreements or domestic agreements here, they are not intended to be legally binding. Meaning here, they don't really anticipate that they might be suing each other in the courts later. Or they cannot really use the word see you in court. Cannot lah. Okay, we cannot use that common phrases lah, because it's just merely social and domestic, okay, as far as the agreements are concerned. But then again, remember, whenever you see the word presume, okay, usually it is something which is rebuttable. You can prove it to the contrary by bringing evidence, okay. All right. So if it can be shown, okay, it can be proved that the transaction, okay, the agreement had the opposite intention, then the court may be prepared. The court is ready, okay. The court may be prepared to rebut the presumption, okay, as prescribed in the rule, and the court will try to find necessary intention for a contract. Still, even though it's between family members or between friends, for example, there could be necessary intention. But what's the evidence? Need to produce strong evidence to rebut the presumption under the general rule. So rule here actually is general rule. Rebutting presumption is the exception to the general rule for social and domestic agreements. Easy kan? Okay, straightforward. All right. But then in reality, is it simple or is it easy to rebut the presumption here? Based on case law lah, okay, decided cases, usually it is quite challenging, okay. It is a difficult task to convince the court in order to rebut the presumption. Normally, the court is so comfortable to just apply the general rule. The court will simply say, oh, it's between father and daughter. Oh, you are just family, so no intention. Cannot sue each other or cannot enforce the contract, basically. Okay, but let's say the party really insists and then bringing in the evidence, then the court might say, oh, you have the intention, okay, rather than you don't have intention. Okay, but then there must be strong evidence, okay, to rebut the presumption. Is everyone okay? All right, we haven't gone to the cases lah. Okay, so make sure that you are clear with the rule. Okay, the second group of people or second type of agreement here, business or commercial agreement. So as the words denotes kan, whatever things related to business or commercial, there must be intention. I mean, the party really want it, okay, want to execute lah, legally speaking. So presumption is that the parties intend to create legal relations and they intend to be bound by the contract. They want to enter into the contract. And then, similar to the first one, okay, in order to defeat or rebut this presumption, there must be something which is very expressive in nature. Okay, it must be expressed to the contrary. Okay, so precisely, so obvious or so clear that outsiders, including the court, may have no difficulty in understanding what they mean. I mean, there must be strong words in order to say, oh, we don't intend to be legally bound, or we are not going to sue each other, for example. Okay, because normally the court will say, well, you have the right to sue each other because this is something which is business or commercial in nature. All right. So example, I mean, one of the common ways, okay, presumption can be rebutted by inclusion or incorporation of express statement to that effects in the agreement. I mean, they have to put it in their agreement. We don't intend to be legally bound, or we don't anticipate whatever legal recourse later or legal proceeding later. They have to make it very clear in their agreement. Otherwise, they have the right to sue each other in the court in order to enforce their contract. Okay, let's move further. This is actually summary. Okay, and this is the list of cases that we're going to discuss today. Okay, if you have done your LLB, okay, so again, this is just refresher course lah, obviously, because you learn all the cases during your undergraduate years, okay. But for those who have yet to take LLB, maybe this is the first time that you are listening to the case, kan? So for example, Nurul, okay, you are going to listen to all the cases lah today. But for Aminah dah belajar lah kan. You are from ICOL obviously as well as Syarah kan. So take it as your refresher lah obviously, and it is easy lah for you actually, right? Okay, for social domestic agreement, we have at least how many cases? 1, 2, 3, 4, 5, 6 cases, okay, 6 or 7 cases, yeah, covering different categories of people, okay, but they all fall under social and domestic agreements. Okay, we are going to start with husband and wife, and then we also have agreement or contract pertaining to family members, and then I mean list of family members here, okay, and then also among housemates, okay, sharing household, living together. They are not family, but they live together. So still it is within social agreement, okay, social and domestic, as well as among friends lah. Okay, the last case is pertaining to friends. For business and commercial agreement, you can see not many cases kan, because usually it's very hard to rebut. Okay, so we have all the classic cases here. Jones and Berners, okay, 1938, and then Rose and Frank, 1925, very old, and then Edwards and Skyway, 1964. So this is the 3 leading cases pertaining to intention revolving around business or commercial agreement. Is everyone ready to have a case discussion? Not really discussion lah, case explanation, okay, or lecture. All right. So again, this is again the reiteration just now. Okay. What do we mean by social and domestic agreement? Okay, whenever it involves family lah or certain category of people here, and we have the rule, general rule. Okay, and this is just now. Okay, I have mentioned just now. All right. Let's go to husband and wife. Okay, general rule for husband and wife. Okay, usually the court will presume straight away. Okay, that there's no intention. But provided, okay, when they entered into the agreement, they were living together as a normal husband and wife. Okay, living in amity, okay, living together. I mean, no quarrel whatsoever. Okay, I mean, they're just normal husband and wife. So whatever contract between them, okay, between the two of them, the court will presume, oh, you don't intend to be legally bound. I mean, you can breach lah. Okay, you promise and then you don't keep the promise. You don't have to go. I mean, you cannot go to the court. The court won't entertain because why? The rule is that is presumed not to be legally binding. Okay, that's the general rule. But then we also have cases. This is to illustrate general rule, and cases to illustrate exception to the rule. Okay, the case of Balfour, okay, whenever you see the same name, it means it involves spouse, okay, or even family. Okay, here Balfour. So very, very old case, 1919, okay, 1919. So here defendant was the husband, okay. So he was working in Ceylon, Sri Lanka lah, okay. So she came to England with his wife on holiday, okay. They went for a holiday. And then the husband returned to Ceylon alone, okay, and then the wife remained in England because the wife was not well, okay, due to health conditions or health reasons here. And before leaving the wife, okay, remember they were in normal lah, I mean on holiday, and then the wife fell sick, okay. So defendant, the husband, promised to pay the wife, the plaintiff, 30 pound. Okay, those century kan, those here, 30 pound I think is quite a lot lah here. Okay, 30 pound per month as maintenance. But the husband failed to keep his promise. Okay, then no payment lah. Alright, and later their marriage broke up. But remember, when they entered into the agreement, they were still in good terms lah. Okay, I mean no quarrel whatsoever. Okay, a normal husband and wife. Now a plaintiff brought the case to the court. I mean the wife lah, suing for the maintenance, the failure to pay the maintenance. Alright, but the court said that there are two reasons, okay, or two ratio here. The wife could not succeed. So the wife fail lah, actually. The first one related to our next topic, next week topic. Okay, it's about consideration. The court said, well, here the wife provided no consideration for the promise to pay. I mean, it's only one-sided, no exchange of promises. Okay, and then now the focus for our topic is number 2. The reason number 2 here. Okay, the court clearly reiterate or apply the general rule. Okay, agreements between husband and wife, okay, not contracts. I mean, cannot enforce it. Because why? When they entered into the contract, both parties, okay, do not intend to be legally binding. I mean, it's like normal promises between husband and wife, despite that it has elements of money kan, or financial implication. But because when they entered into the agreement, they were living in amity lah. Okay, let's compare with another one. Okay, this because just now Balfour 1919 kan. Okay, so later case married 1970. Okay, here the court said, well, actually for this case the wife can succeed because why? In this case the spouses, okay, married husband and wife here, when they made the agreement, they were not living together in amity. Okay, I mean they are not on good terms. They were so serious about it. They really mean it lah, as compared to Balfour just now. Okay, let's go to the full facts here. 1970. So in this case, the husband left his wife. Meaning that here they are about to divorce lah actually. Okay, they are not living together anymore. Okay, the husband left his wife. And then later they met. I mean, leaving each other, not living together anymore, and later they met up, okay, to make some arrangements for the future. I mean, they have to discuss lah. I mean about the relationship here, and then during this meeting, okay, the husband agreed to pay 40 pound. You see the difference kan? Tadi 1990, 30. Now after so many years, 1970, 40 je for the maintenance. This is like for Islam, I think nafkah lah kan, isn't it? Maintenance here. Okay, 40 pound per month maintenance. And then the husband need to pay this because the wife would use the money to pay the mortgage lah, okay, whatever installment, maybe house, usually house lah, okay, mortgage. All right, and then they also agreed, okay, when the mortgage was paid off, okay, the husband would transfer the house from joint names to the wife's name. Mean that here they bought a house together, okay, and then it's on mortgage, and then the husband promised, okay, I'll pay you this maintenance, and then you pay the mortgage, and then I'll transfer the house to your name only, okay, once the mortgage was being paid off. All right, and then another interesting part of this case, okay, I mean the wife was so smart lah actually, okay, he made the husband to write down whatever things that they have agreed, okay, even in just a simple piece of paper. I mean, it's really something in black and white here, okay, some written evidence, okay, and the husband signed the paper. Important, okay, write and sign the paper. But of course lah, later, that's why we have the case. Later, husband refused to transfer the house. I mean, for this case, maintenance was paid, okay, mortgage was paid, and then the promise to transfer the house to to the wife name was not honored lah here. Okay, the husband did not keep the promise to transfer. That's why the wife was suing the husband. Okay, so the husband here. What do you think the outcome here? Was there contract or not? Remember, when they entered into the contract, they were still husband and wife, but they were not living together lah, obviously. Okay, what do you think, Nabila? Was there
Yes.
contract? Was okay, enforceable. Okay, yeah. So the wife can succeed lah. Okay, so this is how the court give the judgment or observation by the court here. Okay, when the agreement was made, okay, husband and wife were no longer living together. This is in contrast with Balfour. Okay, so whatever things that they agreed upon, okay, they must have intended to be binding. I mean, they were so serious about it. Okay, and after all, it will actually whatever thing, it will affect their future. Okay, they will base their future actions on it. And what more? Okay, first, they were not living together. That's the first reason. Okay, the second reason, this intention was evidenced by the writing. Important piece of evidence here. Okay, all right. And because of that, the husband had to transfer the house to the wife. Okay, so you can see the difference between Balfour and married. Both involve husband and wife. They are not divorced yet actually when they enter into the agreement. But for Balfour, there's no, they were in amity lah. Okay, there were no quarrel whatsoever. Okay, they were happy with each other. But for married, they were not happy lah, obviously kan. That's why they are not living together anymore. Okay. We also have, even though the case is not in the list, but this is just for comparison purpose. Okay. Gold and gold, again lah, involving a spouse. Okay, also in 1970. Okay, so similar to married. Okay, in this case, the parties had separated. No longer living together. Okay, and then the husband agreed to pay the wife £12 a week. Okay lah, kiranya for a month, 48 kan, 48 pound a month. Okay, but then there's certain phrases here. Okay, he promised that, yeah, I'll pay you 12 pound a week so long as he could manage it. All right. And then, and this word actually was being considered by the court. Okay, would that make any difference to the contract here? Would that make it unenforceable or not here? So this is actually decision by majority. Okay, not unanimous decision. Okay, two agree and another one give dissenting judgment. Lord Danning, okay, dissenting judgment here. Okay, Lord Edmund and Lord Magor, okay, they said those words, okay, the word so long as he could manage it, introduce such an element of uncertainty. It defeats the intention because uncertainty. You must be certain, okay, in order to express your intention here. Okay, uncertainty that the agreement was not intended to create legal relations. So it negates the intention here because of this uncertainty. Okay, but Lord Danning said, no, I disagree with two of you, but still we need to we need to stand by the majority decision here. But Lord Danning said, well, an oral separation agreement by which the husband agrees to pay the wife so much as is legally enforceable. It's okay, we can still enforce it. Okay, and what more, there is ample consideration for such agreement. Lord Danning focus more on consideration rather than intention here. Okay, but for Lord Edmund and Magor said no. These phrases, it negates intention because it contains uncertainty. So slightly different argument lah as compared to married. So married, there's nothing uncertain. Okay, for God cannot apply married because why? There's certain uncertainties here. Okay, but this is majority decision. Dissenting by Lord Danning. Then disagree lah. They say, well, they have intention and there was consideration between them. Okay, alright. So that for comparison purpose. Okay, good. Okay, now back to you. Okay, question again, the three of you. Three ke? Okay, Dr. Zaidi yet to join us. Tapi he responded to my message kan. I thought he's joining us. Hopefully he will join us later. Alright. What is the position of law under Contracts Act 1950? Do we have any specific provisions for intention? Shara and Aminah must be able to answer kan. Do we have any relevant provision under Contracts Act 1950?
No.
Ada tak, Shara?
Tak ada.
Tak ada. That's why our topic today is slightly simple kan. No need to refer to Contracts Act. Okay, we are just relying on all the cases, especially cases at common law. Okay, thank you for the answer. All right. So yes, it is silent. Okay. But then again, we cannot say, oh, since it is silent, then it doesn't exist. No, it is lah. Okay. It is part of the important requirement, vital requirement here. And how do we know? From case law. Remember, okay, statutory provisions, they are always being complemented by case law. So whenever the provision or statute is silent, so we need to look at whatever decided cases. Okay, we call it case law lah. I mean, the law based on cases. Okay, let's go to some of the cases involving family members. I mean, not husband, wife, but family lah. Maybe a parent and child lah most of the time, okay? And now we have local case, okay, reported in MLJ. Also, old case lah, okay, 1959. The case name is Chu Tiong Hin and Chu Hot Sui. Is it a case from Singapore? Yeah, a case is from Singapore. Okay, those days kan, whatever case from Singapore also is reported in MLJ. Because once upon a time, Singapore is part of us kan, part of Malaysia before the separation. Okay, so for this Chu Tiong Hin case, it involved a dispute, okay, between, this is a appeal case, okay, plaintiff and respondent. So plaintiff actually was the father, but not biological father, adoptive father. And who are the defendants here? Appellants lah, they appeal against the decision, okay? They are adopted sons. So it's not their, but I mean, not biological children lah, sons here, okay? Let's have a look at the full facts here. Okay, so the father, okay, and the first wife, and he has second wife later, okay? First wife, they went to live in a farm in Singapore. Because those days kan, many Malaysian, okay, they work in Singapore kan. Even my late father, masa muda, of story, okay, off topic. When he was young, I mean, he was working in Singapore juga. Okay, even my second sister, okay, she was born in Singapore. Okay, but then she still have the birth certificate lah. But the number different lah. The tengah-tengah number tu 71 number kat tengah because she was born in Singapore. Right, the second sister. And then later come back to Malaysia lah for good. Okay, but dia masa muda my father and mother live in Singapore lah. Alright, so coming back to the case Chu Tiong Hin now. So they had two daughters. I mean, they don't have biological sons. Okay, so they have to adopt 5 sons. Ramainya. Okay, the reason they want this son, adopted sons, to help them on the farm lah. Okay, and also they have various family businesses. I mean, they were having some businesses. Okay, and then the wife died. That's why we have the word first wife kan. Okay, the wife died and then the respondent remarried. Second wife lah. I mean, the first wife died and then he remarried. Okay. And then after the first wife died, I mean during the lifetime of the first wife, everything was okay. Okay, now the new wife kan, okay, the new wife, okay, there were family quarrels, okay, and then the respondent, the father, okay, left the family home. I mean, merajuk lah, okay, left the home, and then later the father claimed possession of the farm and other properties, saying that, oh, despite that you have been working on the farm, but it all belonged to me. Okay, so the father was claiming, okay, all the properties here. But the sons, okay, adopted lah, obviously, they challenge lah, they are not agree. I mean, they don't agree, okay. They allege that there was a contract, okay, that is a document between them, okay. And what's the content of the contract here? In this contract, okay, I mean, whatever businesses here, they have contract, okay. Defendant agreed to be adopted. I mean, first is about adoption, okay, and then agreed to work on the farm. And then because they are the one who help to acquire wealth lah, okay, all the harta, all right, they were entitled equally, okay, with plaintiff, with the father, okay, to possession of the farm. So by right, I mean 50 to the father, 50 to the sons lah, basically, all right. And other property. So property here, 2 motor lorries lah, okay, because they have family businesses. So this is the facts. Okay, and the case went up to the Singapore Court of Appeal lah. Okay, here, and the Singapore Court of Appeal held that, okay, agreement between plaintiff and defendant was not binding. So the court just applied the general rule. What's the rule again, class? What's the rule, Syarah?
Agreement between parties not binding.
No intention kan? Alright. So because the court said there was no legal intention for such a family arrangement to be binding. Why do you think the court came to such conclusion? Coming back to facts here. which part actually says that no intention, despite that it was alleged that there was a contract here. Even there was a contract, what's the situation when they entered into the contract? Were they happy actually with each other last time before they quarrel? Kan? I mean, they just live like normal family, okay, happy with each other. I mean, that here they don't intend to sue each other in court lah. Actually, when they entered into the agreement, despite there was agreement, okay, as alleged by the sons lah, okay, all the five adopted sons. So that's why the court is so reluctant, okay, to interfere with family matters or family affairs. What more, if there is no strong evidence, okay, to rebut the presumption. So for this particular case, cannot rebut. Okay, cannot rebut lah. Alright. So alright. So basically the court just apply or upheld the general rule pertaining to family or social and domestic agreement. And even in Malaysia, okay, just now Court of Appeal kan Singapore, right? In Malaysia, 1970. Just now 1959, okay, 1970. So judgment by Federal Court in Sarawak. Okay, the case name is Pyong Kon, okay, and Chon Chaifa. Okay, I don't have the facts here, but basically the court apply the normal rule again. So meaning that here it's very, very hard to rebut the presumption. Okay, so in this case, Federal Court held that agreement between family members not binding. Still, okay, similar observation, okay, like whatever being decided in the case of in the earlier case lah, okay, by Singapore Court of Appeal. All right, let's move further. Another situation, okay, what if whatever agreement between the parties here, okay, living together, okay, family members here, but whatever agreement that they have entered here, it really has serious consequences on them, on their life, okay, on their finance perhaps, okay, or on their overall life here, okay. I mean, if the parties can prove it to the court, okay, so the court is ready to rebut the presumption. But again, the word is may, not necessarily. Okay, here there might be, may or may not here. So this may rebut the presumption. Dek, tolong buka lampu. Gelap. Dah gelap dah. It's 6:45. Okay, the case is Parker and Clark. Now it involves auntie and uncle and nephew and nieces. Okay, family lah still. Okay, but then here it involves serious consequences. Okay, let's get to know who are them. Okay, Parker and Clark here, 1960, common law. So Mrs. Parker, he was the niece of Mrs. Clark. Okay, Parker is the younger lah. Okay, Clark is the auntie. All right, and then they have an agreement. Okay, I mean they entered into specific agreement here. Agreement was made that the Parkers, okay, the niece lah, okay, the niece here, husband and wife, okay, the Parkers would sell their house and live with the Clarks. I mean, okay, we'll sell our house and then we coming to live together with you. And then the agreement as well is specified, okay, they will share the bills, okay, and then the Clarks, the auntie, okay, would leave the house to the Parkers. I mean, it's as if they are family lah, as if mother-daughter kan. I mean, as if parents and child here. And then, Mrs. Clark, the auntie, okay, wrote to the Parkers, giving them the details of expenses and confirming the agreement. So everything was made in writing here. So that's a very strong evidence actually, all right? And then because of that, after they agreed, okay, everything is listed down, okay, detail out here. So the Parkers, the niece, okay, sold their house and moved into their auntie's house lah, okay? And then, Mrs. Clark, I tak nampak dia ada toolbar kat atas. Okay, alright, nampak dah. Mr. Clark, I mean Mr. and Mrs. kan? Okay, Mr. tu the husband of the of auntie, okay? Mr. Clark even changed his will, leaving the house to the Parkers. I mean, oh, we love you, so since you are living with us, so yes, I changed my will and I'm going to leave the house to you. Okay, that's basically the arrangement lah. Right. And as you can expect, kan, that's why we have the case. So later, I mean, after a few years, I think, the couples fell out lah. Okay, they quarrel, okay, and the Parkers were asked to leave. Okay, you move out from my house. Okay, whereas earlier on they have sold off kan the house. Okay, where to live now? All right. So now they are not happy lah. Okay, they are asked to leave the house. So they claim damages for breach of contract. Remember, we have a contract. Now you breach our contract. Okay, you ask us to move out kan. Okay. Now the question, my question to the three of you, because only three kan in my class today. So what's their intention to create legal relations? Tadi I click the recording button ke just now? Tadi did I click the recording button? Now I only remember.
Yeah, it is recording kalau
Recorded ke? Recorded lah.
recording.
Yes.
Tak recorded. But suddenly macam did I click or not? Okay, question. Amina, was their intention to create legal relations as far as Paket and Clark is concerned? Yes or no? Based on the whole story just now.
No,
Kenapa no?
because the Parker they sold the house and
This is something which is serious in nature kan? Selling the house.
yes, because she wrote and give them the details to confirm the
Ah,
agreement.
So it is something which is serious in nature. So we can say there is intention. I mean, there was intention between them. Okay. You sold off the house. I mean that here you really intend. I mean, there must be something legal lah in nature here. All right. So that's basically the finding by the court. All right. So the court said, well, especially there's something in writing here. Okay, usually evidence in writing is very, very important. Okay, the exchange of letters, okay, before they actually move, okay, into the house, showed the two couples, okay, I mean both of them lah, both couples here, they were serious, okay, and the agreement was intended to be legally binding. Okay, there are two reasons here. The first one, okay, the Parkers had sold their own home, something which is very serious in nature. And then another serious one, Mr. Clark, okay, changed his will. So he's very serious to leave the house to the spouse lah. Okay, once he died, but then he was still alive, and then he chased the niece and the husband can. All right. So because of that, there was breach of contract. Okay, so the contract was upheld to have necessary intention. So the Parkers, okay, were entitled to damages for breach of contract. Okay, so again, what's the reason of court coming to the conclusion that there was intention? First, everything was made in writing, okay, and then it really affect the parties here. Okay, what more, the Parkers lah sold off the property, and Mr. Clark even changed his will. So both parties were serious, okay, when they whatever things that they had done lah, okay, right. So finally there was intention, and there was breach of contract lah, okay, breach of the agreement. Okay, let's say, what if I twist the facts a little bit? Okay, usually what if situation. Okay, what if there's nothing in writing? Everything was negotiated or was discussed orally je, maybe through phone ke, or maybe when they have some dinner together. Okay, everything was in oral, and there's nothing about the will, for example. Can we apply the similar judgment? What do you think, Shara?
I think the judgment will come out different because the intention will not be too apparent because there's no exchange of will and also there's no written agreement. So it will be hard for the court to determine the intention of the party.
Okay, all right. I like your answer. Okay, yeah. Maybe there's not insufficient intention lah. Okay. I mean, it's very hard to reconvince the court without something in writing, kan? Okay, thank you. Let's move further. Okay, this is just for comparison purpose. Okay, the case is Tanner and Tanner. Okay, it's a spouse lah, but they are not married here. Okay, they are just living together, or we call it cohabit. Okay, cohabitation. Okay, over there, when you cohabit, it's okay. It's either you want to register your marriage later lah. Okay, civil marriage kan. Alright, Tanner, 1975. So here in this case, because they are not husband wife, so we use the term man and woman. Okay, so a man promise a woman, okay, again it involves a house, that the house in which they had lived together, okay, they are not being married, okay, should be available for her and the couple's children. I mean, they have children together, okay, but they are not legally married. So husband said, okay, the house should be available to you and also for our children. All right. And the court held that, yes, Okay, I mean the court apply the similar rule, okay, like in Parker and Clark just now. Because why? The promise given by the man here had contractual force because in reliance on it, the woman had moved out of her rent control flat, which is something serious in nature. Okay, I mean nobody can simply leave their rent control flat simply like that. Okay, I mean that here there must be something which is very serious consequence lah to the woman. So because of that, so there was contract lah between them. Okay, so and I mean the woman can enforce it. Okay, can sue or can ask for breach compensation for breach of contract here. Similar, okay, tenant, and it involve house moving out from a house. But then we also have another case here. Okay, just now, it's not really parent-child kan just now. Auntie, uncle, okay, niece, nephew, nieces, okay? And this one, woman and man, okay? But whenever it involves parent and child, okay, generally, the court is not ready to say, oh, you have intention, okay, to sue each other later. So normally the court will just apply the general rule, okay, presumed not to be intended to be legally binding. So this is all the hypothetical or example lah here, okay. If a father promised to give his car, okay, to his son, or promise iPhone, for example, to the son, and the son promised to give the father whatever his belonging, okay, in return. So there is an agreement, and because there is consideration. But then if we zoom to intention here, consideration yes, but then intention. But if the father decides not to give the son his car, okay, and the son sues him for breach of contract, the son cannot succeed, okay, because why? Both of the parties, they are related, and then they were on friendly terms, okay, at the date of the agreement. So it negates the intention to be bound, okay. It would be different if they were not on friendly term lah. Maybe some quarrel or they are not living together, okay. I mean, it's like stranger, for example, kan. Here, they are just family, parent and child. So the court usually will just apply the general rule. Okay, this is the case involving mother and daughter. Okay, example just now, father and son. Okay, here, Jones and Pederberton. Jones is the mother. Okay, Jones and Pederberton, 1969. So in 1962, okay, Mrs. Jones, okay, mother, offered a monthly allowance to her daughter. Okay, I mean, why was she making the offer here? Because she want the daughter to live together. I mean, to come back lah to England. If she would, I mean, if the daughter would give up her job in America, I mean, she was working in US lah, okay, and come to England and study to become a barrister. I mean, that's the mother's promise. Okay, I'll give you allowance, okay, if you come back to England and you study to be a lawyer lah, barrister here. All right. And then the daughter agreed actually here, okay, because of accommodation problems, okay, of course lah, over the, especially in London kan, very hard to get accommodation here. So Mrs. Jones bought a house in London. I mean, very rich lah mother. That's why the mother was offering a monthly allowance kan, okay, bought a house in London where the daughter lived and receive rents from other tenants. I mean, living and then rent out part of the house lah. So receive some rents lah, okay, monthly rents from other tenants. Okay, after 5 years, okay, so from 1962 to 1967, okay, they fell out, quarrel lah, okay, here, and Mrs. Jones, the mother, claim the house, okay, I mean, okay, give me back the house, okay, even though I give it to you, now give me back, okay, because they quarrel, even though the daughter had not even passed half of her exam. I mean, not graduated yet lah, okay, because was still studying, okay, so the mother was claiming the house, so where to live kan without the house. All right, and then the case was brought to the court, okay, so the mother was claiming the house from the daughter. That's why Jones and Pederberton, okay. The court held that remember, the court is so reluctant to interfere kan with family affairs here. So the court held that the agreements, okay, were a family arrangement and not intended to be binding, okay. And then the mother was not liable on the maintenance agreement. I mean, despite whatever agreement, okay, they were happy kan when they agreed, okay, here. And then now the mother actually can claim back the house lah. It belonged to the mother. Kesian kan. But then again, if we were to look from the factor of serious consequence, I mean, this is something which is serious, kan? I mean, she give up her job and then she come back to England, but the court didn't focus on that. Okay, now the focus is only, oh, there were family. I mean, they were just parent and child, mother and daughter, and then there's not enough intention here. Okay, right. Are you okay with the case? I mean, if you were in the daughter's position, do you agreeable with the finding by the court? Do you think the house should belong to, I mean, should be given to the daughter, kan? I mean, orally she promised to give, kan, but then she claimed back lah because it's still under the mother's name here. Okay, that's why the court is so, I mean, it's very hard to rebut presumption. Okay, that's usually the practice by the court. What more, whenever it involves family, the court is so reluctant to interfere, okay, with a family arrangement. All right, let's move further. Okay, another situation. Okay, what more nowadays, kan? If you read in social media, I mean, especially in big town, kan, KL or certain areas of KL, one house, okay, but so many tenants, kan, inside the house. I mean, they separate the house into few sections lah, kan? Few, even the room tu okay, but then even living hall or living room tu pun jadi, I mean, you can stay inside here. So mean that here it's possible that there could be many people staying inside a house lah, okay, sharing the household here. Alright. Now the legal situation, okay, sharing a household, but they are not family, they are not related, but they are living together as housemates lah, basically here. Okay, alright. So the rule is that where the parties to the agreement, okay, share a household, but they are not related, okay, what's the court's decision, or what's the court's attitude or approach here? I mean, there's no yes or no, or there's no hard and fast rule here, okay? The court will examine all the circumstances to see was there intention or not. After all, it is still within social and domestic, kan, situation here. Domestic lah, nothing commercial in nature. So we have the case of Simpkins and Pace, 1955. It involved housemates here. Okay, it involves three parties, okay? I mean, three people living together in a house. So defendant, okay? Defendant is the grandmother lah, obviously, and her granddaughter, okay? And the stranger, the plaintiff. So who was the plaintiff? A paying lodger. I mean, stranger lah, lodger, but she paid the rent, okay? And the three of them, okay, they have same hobby, okay? They all contributed to 1/3 of the stake in entering a competition in the defendant's name. They use one name, okay, the grandmother's name, but they all contributed lah in order to join this competition. Okay, 1/3 each lah, okay, whatever money here. All right. And one of the week, okay, they won a big prize, okay. Remember, this is 1955 case, okay, a big prize, 750 pound. Okay, here they won it. But of course, because it's under defendant's name. Now, defendants refused to share. Okay, plaintiff was not happy. So plaintiff brought the case to the court, okay, asking for her share lah, suit for 1/3 of the share. So 750 mean that here she should be entitled for 250, kan, 250 pound here. All right. And then the court examined the whole thing here. Okay, the court held that there was intention because why? The presence of the outsider rebutted the presumption that it was a family agreement and not intended to be binding. I mean, it involved one stranger, one outsider. So we cannot apply the normal rule here. All right. And what another reason, okay, it involves something finance in nature. Okay, mutual arrangement was a joint enterprise, as if you're having business lah here, okay, you contributed the money here. Joint enterprise to which cash was contributed in the expectation of sharing any price, even though there's no proper agreement, but there was understanding, okay, here that they shared to join, and then if they want, they should share the price. So the grandmother cannot simply keep the keep the price in her own name lah, actually. Are you okay with the case? Simple je kan? Alright. So there are two reasons, okay, why the court came to such a conclusion. First, presence of outsider. Another one, it is a joint enterprise involving cash. Okay, if we twist a little bit, maybe the outcome would be different. Okay, compare with this one. Okay, I mean, this is comparison for Simpkin and Pace. Her did not and her did not. Okay, just now ada outsider. But for this case, the court came to a different result. Because why? Here, it involved wife and husband. Remember, not easy kan for the wife to sue husband to ask for her part here. So in this case, Court of Appeal held that a wife who had assisted her husband in making a correct forecast in a football pool, it's like gambling lah here, okay? She was not entitled to share the winnings. Here, first it involved husband and wife. And when she entered, she was, they are on good term lah, normal husband and wife here. Only the husband doesn't want to share the money kan. And the wife didn't contribute the cash pun as compared to Simkin and Pace. So that's why the court just apply the general rule. No intention to create degradation. So too bad lah, the wife cannot get her portion. So very stingy husband here. Okay, until the wife need to ask from the court kan. I mean, brought the case to the court, still cannot succeed. Kesian the wife kan. Alright. So this is the case lah. Hodinot and Hodinot, 1955. Okay, friends. Okay, so we have lots of friends, okay, and then sometimes friends agree, promise to each other. So let's say your friend does not keep his promise or her promise here. Can you sue her in the court? Okay, it depends lah. Alright, the court will examine actually, because friends it goes beyond husband, wife, or even family kan, friends. Still within social or domestic, but then not so near as compared to other categories of relationship here. Alright, so this presumption against contractual intention has been applied by the courts to a variety of arrangements. So, including arrangement for sharing petrol costs where a person is given a lift to work. For example, here, you share lah to go to work kan. Okay, I'll pay you 50 ringgit every week, for example. And then later you don't pay. So can your friends sue you asking for this payment lah for to share the fuel, for example kan. Alright, so this is the case. Coward and Motor Insurance Bureau, 1963. Here. Alright. Here, Mr. Coward, okay, he was taken to work on the pillion of Mr. Cole's motorcycle. Both rode motorcycle lah, alright? And then in return for which service, he paid a weekly sum. So it's not free of charge lah, okay? He paid certain amount of money weekly, okay? Every week he paid regularly. And one unfortunate day, accident happened, okay? And then it is because Mr. Cole's negligence lah, alright? And both of them were killed, these two friends lah. Okay, they died, all right? And then now the wife was suing lah, okay, asking for compensation. So in election for Mr. Coward's widow, because it's Cole's negligence kan, so widow is putting the blame on Mr. Cole, so asking for compensation. And then she was claiming from insurance company lah, obviously, okay? So the question arose in insurance context lah, all right? Related to our topic, whether Mr. Coward here, okay, was a person carried for hire or for reward? Was there any elements of commercial here? Okay, is it something that amounts to income? Okay, here, right? And the Court of Appeal held that Mr. Coward, okay, was not a person carried for hire or reward. They're just still friends lah, something which is social in nature here. See, it doesn't go beyond that boundary. Okay. Right, so basically no intention whatsoever, okay? But later, just now 1963 kan, okay, 1972, similar case happened again, okay? And House of Lords came up with specific tests in order to assist the court to make a decision, okay? The case is Albert and Motor Insurance Bureau, okay? House of Lords formulated the test, okay? We have to, this is the test, very specific test, yeah? Question is whether there is systematic carrying of passenger which went beyond the bounds of a mere social kindness. Or in other words, is it something which is business arrangement or not here? Okay, but for Coward, that one still it is something which is social kindness lah. Okay, it doesn't go to it doesn't amount to systematic carrying of passenger actually. Okay, because sometimes it's like similar to our e-hailing nowadays lah kan. It is something which is commercial or business in nature. Okay, not really among friends. Even though maybe you are carrying your friends, but you at the same time you are having this e-hailing things or whatsoever, so it is something which is business arrangement, okay, despite that the passenger is your friend, okay? So we can apply to modern modern perspective lah, or modern circumstance nowadays. Okay, so this is example, I mean, in relation to insurances now, kan? All right. So it is stated clearly in the insurance, okay, how can your car be used? So this is example, okay, since this is a private car policy, I mean, we have private car policy and we have commercial vehicle policy. So private car, it covers, I mean, certain limitation lah here, all right? Your policy only covers you if your car is used for social, domestic and pleasures purposes and for the policyholder's business. I mean, it covers social domestic only. Okay, if you have something business in nature, it's not covered. All right. So that's why it is stated in the car insurance policy. We will not cover you, for example, if you use your car in the following manner. Okay, especially as a hire by charging rental to use your car. I mean, whatever happen later, we are not going to cover lah. All right. And then in order to be covered, okay, you must buy a commercial vehicle policy to cover for this use. But I think for e-hailing nowadays, ada specific conditions or regulations kan for that, for insurance kan. I mean, it's a must to take insurance so that it covers the passenger as well kan, if there is any mishap or any accident. Okay, coming back to question again, okay. We want to know what's the position of law under Contracts Act 1950. You have answered kan just now tadi. Tadilah, it's the same slide actually, repetition. Okay, we are going to discuss business or commercial agreement. I think we stop, kita berhenti awal sikit, okay? Because the tonight's topic pun not so complicated. So we adjourn our class early, but we are going to continue, resume at 7:45. I mean, once you had your dinner as well as you do your prayer lah. Okay? Alright, so I stop share for a while. And then record boleh ni ke? Can I, pause record. All right, let's continue. So this is the second part. Okay, just now we discussed all the cases under social and domestic agreement. Now we have come to the second one, which is business or commercial agreement. So as I have stated earlier, so there is fixed presumption, very strong presumption actually. The court will presume that both parties intend to create legal relations and they intend to be legally bound to make a contract. And I mean, they are able to sue each other in cases there is any breach of contract between them. And then, is it possible to defeat or rebut the presumption? Yes, it is possible, but there must be some strong evidence, okay? Because sometimes they can just include whatever statement, okay, whatever terms in order to negate the intention. Because usually the court will presume there is intention, okay? I mean, it is so rare. Okay, why suddenly you don't want to be legally bound? Okay, despite that it has elements of business or commercial. Okay, let's move further. Okay, let's go to the case. We have not many cases for business or commercial agreement. Okay, the first case is Rose and Frank Company and Crompton Brothers Limited, 1925. Take note that this case is a very old case, so maybe we won't be having similar scenario nowadays kan in modern world. All right. So for this case, the defendants, they were paper manufacturers and they entered into an agreement with the plaintiff. Okay, so plaintiff actually were their agents lah. All right. So plaintiff were to act as sole agents. Okay, one agents responsible for the sale of paper lah, defendant's paper in the US. And they have written agreement because this is just the commercial, okay, business agreement, business arrangement. So the written agreement between them contain a clause. So which is very rare, very rare. That's why we have a case here, okay? That it was entered, okay, into as a form. I mean, it was not entered into as a formal or legal agreement. I mean, here they want to negate intention between them, okay, and will not be subject to legal jurisdiction in the courts, okay. But whatever agreement that I mean, whatever written agreement here, okay, it was a record of the purpose and intention of the parties, and they agreed to honorably pledge themselves. I mean, they have the honor to pledge lah, okay, whatever terms in the agreement, okay. And then also in the agreement, it is stated clearly, it will be carried through, okay, with mutual loyalty and friendly cooperation. So it's like something arrangement between friends lah, rather than business, okay, purely business here. All right, and then they proceed with their business. So plaintiff placed orders for paper, and then it was accepted by the manufacturer, okay, by the defendant. And then before the orders were sent, okay, defendant had a change of mind, okay, the manufacturer. So defendant terminated the agency agreement, okay, and also refused to send the paper. So having said so, if you notice, there were two agreements involved here. The first one is about agency agreement. The agreement to appoint, okay, plaintiff as the agent. So we call it agency agreement. And another one, the agreement to supply the paper lah. All right, when the plaintiff placed orders, okay, for the paper. So now, I mean, what defendant did was first terminated the agency agreement, and then also defendant refused to deliver or send the paper as ordered by the plaintiff. Right. So and now plaintiff wanted to enforce the agreement between them. Remember, okay, the terms, okay, which is not so something which is out of ordinary lah. Okay, here. So the court held that there were two agreement here. Okay, the sole agency agreement was not binding because in the agreement it is stated clearly, okay, honorable pledge clause. So it negate intention. But then for the second agreement, okay, what I mean about the orders of the paper on the part of plaintiff towards the defendant here, okay, contracts had been created. I mean, it's a normal contract here, okay, and then failure to execute them. So it amounts to breach of contract on the part of the defendant. So for the first one, yes, there's no intention, okay, because of the inclusion, okay, incorporation of specific clause, honorable pledge clause. But for the order, I mean, there's no clause. I mean, it wasn't repeated in the, the order. Okay, I mean, it doesn't state, okay, the order is made under honorable pledge clause whatsoever lah. Okay, it's only about the agency agreement, which is stated clearly, that it is they honorably pledge themselves lah with regards to the agency agreement, but not to when a plaintiff place order, okay, from the defendant. Defendant was the manufacturer. Okay, so I mean that's how the court give judgment. Okay, the court divided into two separate agreements. The first one, lacks of intention, but the second one is just a normal commercial agreement, okay, business agreement. Okay, whenever we see the word binding in honor, okay, I mean, something with regards to your honor. I mean, if you have honor, then you will keep the promise. Okay, you will you will execute. Okay, you will do whatever that you have promised lah. Okay, I mean, we have a case. It relates to football post. Okay, and then I mean, on the ticket lah, it is stated clearly. I mean, if you win a prize, it is binding in honor. I mean, we are going to give you the prize, but only binding in honor. So mean that here, if they don't have the honor, they don't want to give the prize lah. Okay, so they are not legal contracts because a participant may not recover his winning. Okay, despite that he entered into this football post. It's like gambling lah here. Okay, let's go to the facts of the case here. Jones, another classic case here, Jones and Vernon Pools. Okay, because normally whenever you enter into gambling or competition, okay, of course you expect to win a prize, kan? You want to claim the prize, but for this case it's very rare lah. So plaintiff claim to have won the football pools. Okay, pools here relates to betting lah. Okay, gambling or betting here. I mean, they predict certain result or certain outcome here, right? And then what more, the pools are typically cheap to enter and may encourage gamblers to enter several bets. I mean, they join in and then put in many bets lah. All right. And the coupon, I mean, when the plaintiff entered into this pool, football pools or betting here, clearly stated on the coupon, okay, stated that transaction was binding in honor only. Okay, so the court held that because of the specific phrase or clauses here, the plaintiff was not entitled to recover because the agreement was based on the honor of the parties and thus not legally binding. So it's up to the organizer, okay, to the one who organized these football pools, whether they want to honor or not. I mean, if they honor, then it's okay, binding upon them, okay? So they are not legally bound lah here. It negate the intention. It negate the normal intention under business or commercial agreement. I mean, purposely inserted, okay, there's phrases lah to negate intention. So plaintiff, when he entered into such a betting here, he must be aware lah. Actually, he know the risk. Okay, maybe this organizer won't be paying. Okay, despite that he won the betting here or the pools here. Right, so it's okay. I mean, it is allowed. Okay, because of these phrases, it negate the intention. Okay, we also have some of the local cases, but it relates to intention, but not so much on binding in honor, but it is a case relating to intention to create legal relation. Both cases from from High Court. Okay, HC is High Court. One is 2022, very recent. Another one is 2010, and both is under MLJU, unreported. Usually under unreported ni because it doesn't establish a new ruling. Okay, it's not that important, but still it is there lah. Under MLJ, but under category of MLJU. Okay, the first case is CTMCC Engineering and yes, Joss Machinery. And the second case is AHT Properties and Tan Yihi. I prepared a summary of this case. Usually it's very challenging if you read MLJU because there's no specific no specific cash praise or no specific summary. So you have to read through and then you do summary on your own lah, basically. So I did my own summary. But if you read full, then you appreciate the case better lah. It's quite long actually, the case. But I just zoom to the relevant part here. Here it involves certain purchase of machinery, not really machinery, but the one in the picture. It is named, it is called passenger hoist. Okay, so plaintiff in Malaysia, company in Malaysia, purchase certain machineries from the defendant. Defendant actually in China. I mean, they are the one who supply all this machinery lah to plaintiff in Malaysia. So plaintiff paid the 30% deposit. Okay, but on the part of defendant, eventual failure to deliver. Actually, if you read the full report, defendant did attempt to deliver, but there's a problem with is it immigration? I mean, you need to get certain approval kan in order to for the things to be delivered to the site lah, construction site here. But eventually there's no delivery lah, failed to deliver by whatever reasons here. Okay, to the project site as required under purchase order. Okay, purchase order by plaintiff, so it's defendant. Now, on the part of defendant, as a plaintiff sued for the return of the deposit and also other damages lah, other types of compensation. And then defendant try to defend their case. Okay, defenders S here allege that they rely on initial agreement. Meaning, okay, we know that you have submitted purchase order, but we have initial agreement between us. Okay, initial agreement plus discussion. Okay, actually in the discussion, in the agreement, we agreed to supply 9 units. Okay, and not the I think when they wanted to send is 3 or 4 units only. Okay, they said, oh, I mean, it's not really failure yet lah. Okay, we are about to supply all the units. Okay, supply 9 units of passenger hoist. So they try to prove this to the court lah in order to defend their case. Alright, but the court held that from the evidence produced in the court, okay, the court came to the conclusion there was no such discussion that shows the parties intended to be bound with the initial negotiation. I mean, in lacks of intention, okay, whatever negotiation is not, it doesn't place legal obligation yet. Okay, initial negotiation. So no essential terms have been agreed upon by the parties, except the court only rely on the purchase order lah. Then purchase order has the necessary legal intention, okay, on whatever terms in the purchase order. And then it is also clearly stated, okay, in the decision by the court, High Court, okay, the law is unwilling to give legally binding force to agreements which are too uncertain. So whatever initial agreement, whatever negotiation, I mean, it is not really certain lah. Okay, so it lacks of intention. So that's how we relate to the topic or discussion of intention to create legal relations. So intention was present when the plaintiff submitted purchase order and all the terms are there. So everything was clear by that time lah. Okay, so whatever thing earlier, the court were not the court were not prepared to say, oh, there was intention. Okay, and whatever units that you agree earlier on, everything must be there in the purchase order. Right? Are you okay? So that's the case. Actually, it's a long case, but I cut short and then I just zoom to the relevant part so that it is relevant to our discussion. Okay, let's go to another case, AHT. This one also MLJU, okay, but This one is 2010. Another complicated case because I have to do my own summary and then I try to summarize, especially it involves many agreements for this particular case. Okay, so the case involves certain sale of shares together with purchase of land. That's why it is complicated. I mean, you need to purchase share together with the land here. And then now plaintiffs, they sued all the 11 defendants. That's why the case are complicated. Many parties involved and many documents lah. Okay, many agreement for specific performance. I mean, now plaintiff wanted to compel the defendant lah. Okay, under agreement to purchase all shares. And then, because many agreement involved, so the final agreement, okay, after having been signed by the second and fourth plaintiff, I mean, many plaintiff and many defendant here, and then was taken away by the third defendant for execution. I mean, final agreement, plaintiff signed first, and then defendant take it. Okay, they want to execute, okay, by all the shareholders. But on the part of defendant, it was never signed or returned to the solicitor. So it stopped there. I say it's not completed lah. Okay, a plaintiff signed. Okay, everything was signed by plaintiff, the final agreement. But on the part of defendant, they failed to execute. Okay, that's why now the plaintiff is asking for specific performance to compel or to proceed lah. Okay, with the agreement here. And then many argument. So one of the arguments, missing as one of the arguments was based on lacks of intention to create legal relation. That's why it's related to our topic. Okay, so the court held that, I mean, the court examined all the document involved, and one of the document was confirmation letter. Okay, even though the confirmation letter may appear simple and bare in its term, I mean, but it has the intention to create legal terms in respect of passing ownership of the sale land because it involves shares as well as the land. Okay, and then one of the document confirmation letter. So the letter actually has intention. I mean, it's very clear lah, all right? And the court held that because of that, okay, the court held that the agreement was valid, binding and subsisting, okay, against all the 11 defendants, and then all parties who have yet to execute, because now the plaintiff wanted to compel them to execute lah, to proceed kan. So the court give judgment in favor of the plaintiff, okay, who have yet to execute the final agreement, and the court ordered them to execute it within 7 days lah, because there was intention, okay, when they agreed to execute, but they just omitted to execute. I mean, they don't want to proceed lah basically here. And then they claim, oh, there was no intention. But the letter said, well, you have intention to enter into the agreement. Are you okay with the case? I think it relates to intention to create legal relation. This is local cases lah. Okay, let's go to the second part of the second, I mean, still it is about commercial agreement, okay? But in this, whenever it relates to, we have 6 boxes here, okay? There could be no contract created, okay? Because general rule, there is contract kan? But whenever it involves this situation or circumstances here, there might be no contract, okay? Despite it relates to commercial agreement. Okay, we are going to look at ambiguous words, okay? And then, I mean, mere path or ambiguous words. We are going to look at collective agreement, and then MOU, letter of intent, letter of award, and letter of comfort. Okay, all relates to intention to create legal relations. And these situations might negate the intention. I mean, maybe there's no intention, despite that it is still a contractual document, but it lacks of intention. Okay, we are going to have a look one by one. Okay, the first one. I mean, that's the explanation. Okay, there are situations where it will appear, okay, apparently at first sight, okay, on the face of it, the parties, okay, the contracting parties here, they had entered into commercial agreement. But if we look closer, okay, or if we examine deeper, okay, there's no contract. Okay, a contract is not created. Okay, the first one. All right. So the first one, mere puff. Okay, I know you haven't taken your dinner, but here it's not curry puff, okay, mere puff here, okay, exaggerated words, okay, or gimmick, mere puff, or even ambiguous words. So we have section 30, okay, kan, in the early part of the lecture, I mentioned there's no provision kan, but there's one provision lah, not really directly, but relevant, because it talk about uncertainty, okay, section 30 of Contract Act 1950. And then we are also discussing collective agreements. That's okay. Okay. Question. I mean, before we go to discuss mere path, okay, do you know what is collective agreement? what are collective agreements? Any example of collective agreement? I mean, are you familiar with the terms? Nurul, collective agreement involving who are the parties usually? Whenever we mention collective agreement, what first come to your mind?
Offerer and offeree.
Sorry?
Offerer and offeree.
More specific. Relates to what? What situation? Specific situation, specific parties, specific circumstances. Amina, are you there? Collective agreement. Example. Involving whom usually? Of course lah, offerer, offeree. Okay, but then who are they? Aminah tak ada. Syarah?
I don't have. I don't know.
You don't know. Syarah?
I'm not sure, but I think collective agreements example is when employees, like a group of
Yeah.
people.
Dah, almost. You're almost there. Almost correct. Dr. Zaidi, any idea? Collective agreements.
Yes. One example, basically, if you
Dah panjang je. Saya pandang.
okay,
Bagi je
remember
direct
that
question.
about the NUP, national
Betul. Yeah,
NUP.
you got it correct.
Yes.
Okay.
Yeah,
It
NUP
relates to
between
trade
the
union.
banker, yes, bank union
Betul.
between the okay, thank you.
Pandainya. Because you are doctor, that's why you can answer correct.
Okay, thank you.
Okay, thank you. Okay, let's go to the slide. So basically, whenever we have agreements between a trade union, okay, and an employer lah, like mentioned by Shara just now, kan, okay, usually they want to regulate rates of pay and conditions of work lah. They want to, focus is on the welfare of the employee, okay. They ask for increment, okay, they're asking for bonus, for example, okay. And then the peculiar part of collective agreement, okay, if the terms in this agreement, okay, of such agreement, if the terms are not incorporated into individual employees' contract of service, employment contract, okay, they will not be legally binding on the parties. All right. So like, Dr. Zaidi dah have answered the question. Any example of trade union just now, kan? Okay, new bankers, kan? And then teachers as well, okay, they have trade union. Certain profession, they have trade union and they are very strong, okay, in order to ask for their rights, for example. They are so vocal, okay, to uphold their rights lah, okay, rights and interests here. And you might want to cross-refer to IRA, okay, Industrial Relations Act, especially section 2, 15, 16, 17. It talk about this thing lah, okay, relating to trade union, okay. All right, so in England, okay, let's have a look at positioning because you have a case law on this. In England, although collective agreements are commercial in nature, because of course it involves business kan, commercial, but they outweigh by other consideration. The court will consider all these things, okay, despite that they are commercial in nature. Okay, the court will look at the actual wordings used, okay, wordings of the agreement, nature, as well as climate of industrial opinion adverse to having them legally enforceable. All the consideration by the court lah here. So we have a case, Ford Motor and Amalgamated Union of Engineering and Foundry Workers. Okay, what's the facts here? All right. Ford Motors, okay, and trade union, they reach a collective agreement lah. Okay, so concerning employment conditions, okay, and the agreement was properly signed by their representative, okay, by both Ford Motors and this trade union, okay. And then later there's a strike lah, okay. So a union strike took place, okay, concerning the conditions. So now the company brought an action for injunction pursuant to the agreement. They ask for injunction, but they rely on the agreement. And then they attest that collective agreements to be legally binding. But the unions argued that no legally enforceable contract resulted from the collective agreement. All right, so the court is now given the task, okay, to ascertain does it have any intention or not, okay? So examining a range of factors lah, a long list of factors here, the court concluded that, okay, the collective agreement primarily considered the parties' optimistic aspiration, okay, and did not contemplate legal enforceability. So the court just applied the normal rule pertaining to collective agreement. Thus, okay, the parties did not have the intention to make the collective agreement binding at law lah. Okay, I mean, whatever negotiation, whatever agreement here is not really binding unless the employer agree to incorporate, okay, whatever things in the collective agreement into proper employment contract. I mean, that's the rule under, I mean, from this case, Ford Motor and Amalgamated Union. But now we have ISA, Industrial, I mean, IRA, Industrial Relations Act, which regulate lah to some extent all this thing. You might want to have a look later. Alright. Tadi we haven't discussed MIRPAF eh. Oh here, lepas ni MIRPAF. Okay, now we go to MOU. I think all of us are familiar kan with the term MOU. Okay, MOU mean that here understanding each other lah. I understand you, you understand me kan, alright? So the term MOU, okay, it reflect a memorandum witnessing mutual understanding or intention, okay, mutual intention of the parties. I mean, what's the understanding here? Okay, they agree to do a certain act or they agree to enter into certain arrangement, okay? But of course, usually upon the occurrence of certain other events. So most of the time, okay, MOU, the nature of MOU is that it is a preparatory agreement, preparation, okay, for preliminary arrangement. I mean, there might be executing or signing another specific agreement lah. So MOU is like preparation or stepping stone kan. Okay, it's like the first step, okay, before they enter into specific agreement lah. That's basically MOU. Alright. We are going to discuss as well letter of intent, letter of what? Letter of comfort. All relates to intention actually. Okay, alright. Whether there is sufficient legal intention or not between the parties. But before that, we go to the first one tadi, mere puff. Okay, mere puff or ambiguous words. Okay, what more I think is relevant nowadays kan? Whenever you see advertisement on social media, okay, advertisement on TV, okay, wherever lah you see on the internet. Alright, we might come across some claim which is so exaggerated. Okay, everything is so terpaling kan. I mean, one supplement, okay, can heal a list of diseases kan, illness for example. Okay, so for the purpose of attracting custom, okay, tradesmen lah, businessmen, okay, salah, they may make very exaggerated claims, okay, or vague claims lah, okay, in advertisement. And then generally, okay, such statements are essentially statements of opinion or mere path. I mean, that's the court's attitude lah, okay? And usually they are not intended to form the basis of a binding contract. After all, unless it is a term of the contract, okay? Usually it's just a mere advertisement. Remember, advertisement is just invitation to trade kan, alright? I mean, to make offer. Usually it's not part of the terms of the offer. Okay, now question to all. Okay, everyone need to give example. Any example of mere path that you come across nowadays? Start with Dr. Zaidi. Mere path, example, real one. Example of mere path or ambiguous words. Or we pass the baton to Shara first. Okay, we come back to you later. Shara, any example of mere path? Exaggerated claims.
Mere path in a contract.
Example. Advertisement that you come across.
Oh, advertisement kalau macam ubat putih dalam 7 hari.
Okay. But maybe you can be, I mean, it can do the whitening within 7 days perhaps.
Yeah.
Exaggerated jugalah, alright. It has some, some exaggerated, some elements of exaggeration. Okay, example from Aminah, other than whitening.
Some advertisement claim their product is world best product and like that.
The word best tu kan, I mean, sometimes they use, the best in Malaysia or number one kan, they like to claim. But who actually verify, are you really number one kan, isn't it? Possible lah, alright, example. Nurul, any example? Exaggerated claims in adverts.
Medicated bed, as in sleeping on the bed for some time can heal whatever illness we have.
But there
But
comes all the testimony kan. Testimony, oh makcik dah sembuh lah after using this mattress for example kan. Because there's no scientific proof or whatever experiment based. But they do, I mean that's how they convince the potential consumer kan. Potential buyer. Dr. Zaidi, we are coming back to you. Any example?
Yes, maybe okay, my example I don't know whether it's right or wrong. Maybe PDRM mesra cepat dan betul.
Oh pula. Okay, but that one it involves civil servant kan. Now we're talking about
Okay.
tradesman.
Oh, okay.
Business.
Business
Ada any product that you come across that you don't believe in them? I mean, oh, memang puff je ni, ambiguous, or it's just a mere gimmick.
Maybe what we call is a good process on the secretary company.
You are being too complicated kan. Just give any product. Any product lah kan. I come across product macam oh boleh apa can make you taller kan. Ada produk kan. I mean they claim that you can be taller by I'm not sure what's the methods or what's the thing that you have to consume ke so that you can be taller even though you are now an adult kan.
Yes. Maybe what we call this 1 month to be to develop the six pack muscle.
Yeah. Yelah, all the whatever to lose weight kan usually slimming products sometimes. Okay, so all right. So thanks for all the example. We are looking at section 30 now. Okay, section 30 of Contracts Act 1950.
Doktor,
Yeah.
yang Mia Puff tu boleh relate to the case of Carlyle carbolic smoke.
Boleh,
Case
but
tu
then
kan?
that one falls under exception because it becomes an offer straight away because the terms are so clear, not really puff lah. The terms that they have deposited the money, okay, and then it provides for clear instruction. I mean, you buy, you use, and then you caught flu, okay, and you can come and claim to us. So it's not really mere puff lah. It's very specific, very clear, and you claim that you have money deposited in the bank, kan? So you are ready to pay, okay. But whoever come and claim lah, you cannot say, oh, we don't have intention to pay, cannot. Alright, you'll be in breach. Yeah, it is a puff, but then it falls under exception rather than mere puff. Okay, thanks for asking. Good. Okay, this is section 30 of Contracts Act 1950. It talk about agreements void for uncertainty. So the keyword here is uncertainty. So agreements, the meaning of which is not certain, okay, or not capable of being made certain, so agreements are void. So we have 5 illustrations here. Example lah, okay. Example here, A. Okay, we have a look at A. A and B is a person. Okay, I mean refers to the person, contracting party. A agrees to sell to B 100 tons of oil. Okay, but there is nothing whatever to show that what kind of oil was intended. Okay, the agreement is void for uncertainty. So must be very specific. What oil is this? Okay, is it cooking oil or is it medicated oil or is it all fuel here? So it has to be very specific. So this is something which is very, very uncertain. Okay, we choose another example. Okay, Amina, read B and then explain so that you have a reading task tonight. Illustration B.
A agrees to sell to B 100 tons of oil of a specified description known as an article of commerce. There is no certainty here to make the agreement void.
There is no uncertainty.
There is no uncertainty here to make the agreement.
I mean, here is very certain. Because why? It is stated here, specified description kan? And then very specific, article of commerce lah. Okay, it relates to business. So very, very specific. Thank you. Shara, read C.
A, who is a dealer in coconut oil only, agrees to sell to B 100 tons of oil. The nature of A's trade affords an indications of the meaning of the words, and A has entered into a contract for the sale of 100 tons of coconut oil.
So here certain or uncertain?
Certain, because A is a dealer of coconut oil, so whatever he sells means that he sells coconut oil.
So impliedly, I mean you are buying coconut oil lah. You are not buying medicated oil kan, minyak cakapak whatsoever. Right, thanks. Nurul, read D.
A agrees to sell to B 1,000 gantangs of rice at a price to be fixed by C, as the price is capable of being made certain. There is no uncertainty here to make the agreement void.
I ask you to read D kan, nama skip
Oh,
pula.
A agrees,
D.
sorry. A agrees to sell to B all grain in my granary at Ipoh. There is no uncertainty here to make the agreement void.
So everything is certain lah here. Alright, very clear. Okay, Dr. Zaidi, you read the last one, F. Ada ke tak? Are you there in front of your computer?
Okay, all right. Okay, I will agree to sell to be my what host for the 500 ringgit and 1,000 ringgit.
Bukan
This is
and
nothing to
or.
show.
Bukan and
Yes.
or.
Oh, sorry, all 1,000 ringgit. This is nothing to show which of the two price was to be given. The agreement is void.
Why it is void?
Okay. Okay.
Tadi you baca kan?
Yeah, 500.
Why it is void?
Benar.
There's background noise kan over there. That's
Yes,
why.
yes.
Okay, understood.
All right.
Kenapa? Why do you think the agreement is void? What is so uncertain here?
Okay, because Sedi host for the 500 and 1,000 ringgit. There's nothing to show. So
You cannot give two prices kan for one
Yes.
single horse.
Yes.
Certain lah nak jual
Yes.
at what price.
Yes.
So the price is uncertain here. That's why agreement
Yes.
is void. Okay, thank you. Okay, ambiguity still related to uncertainty or part of just now. Okay, so if a clause, the rule here, if a clause is put in an agreement and the clause is so ambiguous, okay, so what's the court's role or task here? The courts will intervene and try to interpret it because the court doesn't want to nullify a contract just because of ambiguities. Okay, example here. Assume that Mr. A has been made redundant. Okay, I mean no longer needed lah the service here. And his employer has promised to make an ex gratia payment. I mean very specific term used here, ex gratia payment. And later, I mean promise comes first and then later employer refuses to make the payment lah because they agree to pay but only on the basis of ex gratia. Okay, now does Mr. A, okay, the employee have an action against his employer? Can he sue based on this ex gratia payment? Okay, let's move further. We have a case on this actually. Okay, what's the meaning of the word ex gratia? Okay, so it is a Latin term which means out of goodwill. Okay, I mean, does it negate intention here? So ex gratia is a sum of money paid, okay, when there was no obligation or liability to pay. Mean that here, okay, if I want to pay, I pay, but there's no obligation lah or liability if I don't want to pay. Okay, example here, a lump sum payment over and above the pension benefits of a retiring employee. I mean, it is a practice lah in Malaysia, civil servant, okay, who has served for certain years kan, and then they are about, I mean they want to retire, so they will get pension. I mean those pensioner lah, those who are entitled for pension, and then they will also receive something which is known as ex gratia or gratuity kan. But then again, this is above the benefit. I mean usually if government have money they will pay, but of course they will have money lah. So for now kan, maybe later not enough money to pay. So generally, okay, there's no obligation for the government to pay, right? I mean that's the rule lah. But now the practice is that there will be payment lah of this. We call it ex gratia or gratuity. Let's move further. Okay, we have a case on this, Edwards and Skyways, okay, 1964. So this case is important because why? It demonstrates that if a party, okay, in a commercial agreement wishes to claim, okay, that part of the agreement is not intended to be legally binding, so they must prove it. I mean, they want to say, oh, we don't have intention to pay. So they must prove with strong evidence lah. So they have the evidential burden of proof. Because why? The court will try to uphold there is intention. Okay, the assumption will always be that commercial dealings involving employer-employee, okay, will be intended to create legal relations. I mean, it's not a merely domestic or social in nature. Okay, it is something which is business or commercial in nature. Okay, let's have a look at the facts of the case. Okay, Mr. Edward Skyway. Okay, Mr. Edwards, he was a pilot and he was made redundant by Skyways. I mean, they no longer need his service. Okay, and as part of the, they have this arrangement, okay, redundancy arrangement. I think in Malaysia, we also have like VSS lah, voluntary separation scheme, similar to this scheme. So he was offered the opportunity to withdraw his contribution to the company pension scheme, and or he has the option to allow it to mature and claims at 50. I mean, he can, he has the option, the choice, he can withdraw, I mean, no need to pay, or they can, he can still wait, allow it to mature, and he can claim at the age of 50. I mean, that's the option lah given to him. And then, in the interest of the company, okay, actually the company wanted him to withdraw lah. Okay, so if you withdraw, so we'll pay you ex gratia payment, all right? And then later, a company refused to honor the arrangement. Okay, I mean, okay, we promised to pay, but later they don't want to pay. Okay, this ex gratia payment. And in its defense, I mean, Edwards sued the Skyway, sued the company. So in its defense, Skyway claimed that they purposely use the term ex gratia because they don't want to have any intention to create legal relations. I mean, ex gratia, lacks of intention lah. But the court decided that this was not a strong enough argument, okay, to overturn the assumption that commercial dealings are contractual. I mean, the fact that you use the term, okay, ex gratia, still is not strong, okay, to say, oh, there's no intention. There was intention between this employer and employee. Okay. Alright, so when we talk about ex gratia payment here, okay, it refers to termination agreement lah. It relates to termination agreement pertaining to employment contract. Okay, so in that context, okay, both employer and employee, okay, they may agree voluntarily to cease, to stop the employment contract, and they might enter into a, we call it, they call mutual separation agreement, similar to VSS lah, voluntary separation agreement. And normally, the employer will offer a separation benefits or ex gratia payment, okay, in consideration for the cessation of the employment contract. And then, there's no specific procedure lah or formalities to observe because it's merely arrangement between employer and employee. And the fact that they use this term, it doesn't mean that, oh, they don't, they can escape from paying lah because they have agreed to pay. Okay, despite the term used ex gratia payment, they have to pay actually. Okay, it is still within the context of commercial agreement. There was intention. Okay, all right. Like Aminah asked just now, okay, now we are referring to Kalal, okay, because why in Kalal it sounds like a puff, but then there was intention, okay. Here the court came, the finding by the court is that the pledges or promises in the advertisement was very, very specific. Okay, specific pledges. It's not very vague. It's not very ambiguous here. Okay, because it's stated kind of clearly. Example that we can find in modern advertisement. If you can find the same holiday at a lower price in a different brochure or at different retail store, we will refund you the difference lah. So actually, this is very specific. You can actually sue, okay, to ask for the payment here. I think I come across this kind of advertisement many times lah. For example, Giant Batu Cave, in their brochure, okay, kalau jumpa anywhere cheaper than our price, then we are going to refund to you lah the money. But I doubt lah whether you really wanted to claim kan from them, even though you can find cheaper kan elsewhere, isn't it? It's very hassle, isn't it, to ask, to claim after all. Okay, coming back to Kalal here, one of the defenses raised by Carbolic Smoke Ball, okay, was that they did not intend to create legal relations, okay, because they claim whatever advertisement, okay, that they put in the newspaper was a mere business puff. It's just a business gimmick. They don't want to pay actually. But the Court of Appeal rejected this defense, okay, this argument, because the court held that, well, you mentioned clearly you had deposited £1,000 in the bank. Very clear, okay, clear amount stated here. And it shows your sincerity, and it is an evidence that you have intention to pay, okay, to anyone who use your medicine and still caught flu lah. Okay, that's why Mrs. Carlyle managed to claim lah, okay, succeeded to claim against the company. Okay, balik smart ball. Alright, sama lah, okay, this one in the third boxes now. Alright, another case, okay, just for comparison purpose, okay, we have a very 17th century case, okay, because over there is properly recorded, kan, all the cases. So we have this example of the case, classic case here. The case name is Wicks and Tybolt, okay, 1605 lah, 17th century case. Here the things that we derive, the rule here, a statement will not be binding, okay, if the court considers that it was not seriously meant. It's like you don't intend lah whatever things that you said or whatever things that you uttered here. Okay, here in this case, the defendant the father actually here, okay, affirm and publish, okay, that he said lah in the public that he would give 100 pound, okay, those century very big amount, okay, to him here, any candidates, okay, that should marry his daughter with his consent. He was offering amount of money lah, okay, whoever wanted to marry my daughter, so I'll pay him, okay, 100 pound. Okay, remember this is 17th century case, okay, but the court held that here, well, you are not serious lah. The father was not serious in making such a statement here, because the court held that it's not reasonable that the defendant, okay, should be bound by such general words. Okay, the words are so general, and the real intention is to excite suitors, any potential son-in-law or candidates lah, okay, to come forward and try to be his son-in-law or to marry his daughter. Okay, lacks of intention here. All right. Despite that there's a specific amount of money, but in the context of the words being spoken here, okay, no intention. Whoever came forward and then asked to marry lah for her daughter here cannot claim lah actually. That's what the court said. Okay. Alright, but again, take note of the year in which the case was decided. Maybe different judgment, okay, if it were to happen nowadays, kan, okay, lots of not really funny, but then unusual stories, kan, that we heard. So maybe if it happens nowadays, if everything is so clear, very specific, maybe you can actually try to enforce it in the course of law, kan. But here in 17th century, the court said, well, this is not seriously meant lah. Not really intention. Or maybe nowadays, kan, the defense would be, oh, buat content je. It's merely content, kan, for your whatever video, whatever thing that you uploaded or posted on your social media. So still, it is lacks of intention. Okay, let's move further. All right. What if, okay, still is about ambiguity just now, okay? What if the contract contains meaningless term? Anyone would like to try to answer? Can we enforce it? Does it have intention or not? Okay, meaningless term. You have a term in your contract, but it contains certain phrases or word in which meaningless terms here. Will that affect intention to create legal relations? What do you think? Dr. Zaidi, what do you think?
Okay, basically meaningless meaning basically we come to the what we call is the main of the content of contract basically, because sometimes the main of the contract just describe about the certain things, but from the certain thing maybe we can elaborate, but come to the elaborate maybe the contract less about the term and some things that, but maybe we can relate to the main of the content of the contract.
Will that affect enforceability of a contract if the contract contain a meaningless term?
Yes.
You cannot enforce the contract because it contains meaningless term.
Okay.
Can compel ke cannot compel? Can proceed or not with the contract?
Actually, okay, actually
Apa
it's
tak soalan
depend
ni?
of the, okay, actually it's depend of the case by case lah, I think, because sometimes how clear the case that we can relate between the contract content, is there any related to that the case, and then if let's say they have a related to in that case, and then clearly on the main of the contract content, then okay. If let's say maybe they have a specific that claim by another party, that okay, maybe if let's say the
Panjangnya
claim
jawapan you, alright.
okay,
Still
maybe the claim
answer.
is clear, then fine, maybe a part
So
of
it
them.
depends whether clear or not lah, actually.
Yes, yes, it is depend, and then it's
Thank
depend
you.
of the claim basically. Okay.
Thank you. Alright, Shara, what do you think? If it contains meaningless term, can we enforce it or not? Will that affect enforceability of a contract? Will that negate intention?
Meaningless. I think you can still enforce the contract.
Can still enforce.
Yeah.
A good guess, but we want to know why actually. Okay, never mind. Okay, we have a case here, another classic case, 1953. The case is Nicolin and Simmons. Okay, reported in Queen's Bench, QB. So this case is important because why? It demonstrates how a court may choose to allow a contract to stand. I mean, yes, you can proceed or you can enforce it, even if parts of it are meaningless. I mean, it won't affect the whole contract lah here. Okay, so the contract in this particular case, it contained the words subject to the usual conditions of acceptance. Whereas the parties, that's the first time ever they had a dealing here. Okay, the parties had not done business before. How come you use the word usual? Okay? As if you have earlier dealings. Okay, so it was impossible to tell what the usual conditions were. But still the court said, well, it doesn't affect the whole contract here. Okay, I mean, it won't affect the enforceability. And then, all right. So the court ruled that this phrase should simply be ignored. I mean, we just ignore lah. We also have the term like sever. Sever. We can just cut lah. Right. We just remove or we just delete. So the rest of the contract left to stand. We can still enforce the rest of the contract. And then one of the argument, actually, anyone who wanted to renege or doesn't want to honor the promise on a contract could have it avoided on technicality. So we don't want to allow technicality to affect the enforceability of a contract. So if it contains certain meaningless term or phrases, I mean, we can just ignore lah. We just enforce whatever are the parts of the contract. So you are right lah, Syarah. Okay, your answer is correct. Dr. Zaidi answer pun correct juga, cuma panjang kan. I mean, panjangnya you explain very well and then we want to know what the answer actually. All right, thank you. So let's move further. We have 20 minutes to, I mean, we are about to finish. This is actually how to differentiate between contract and MOU, because generally contract is binding, but MOU usually is not legally binding. Okay, but then how do we tell the difference here? Okay, how do we draw a demarcation line? How do we distinguish between these two types of document? Okay, so most of the time, MOU may not be legally enforceable because usually it's very general, very broad in the terms lah. Okay, and MOU may be just a bare bones lah legal contract, and usually it leave itself open to interpretation, and I mean, because it is just a mere preparation to a specific agreement. So that's the function of general MOU. But then again, each case must be decided on its own facts. Because why? Sometimes, despite that you label it as MOU, actually it's a specific contract already. It's possible lah to find such circumstance lah. So the court task is to look at the intention of the parties, whether the parties really intend to create a legal relationship there and then. I mean, there's no need to enter into another specific agreement. MOU will be sufficient in that particular situation. So we have this case by Court of Appeal 1995, Sia Siu Hong and Lim Gim Chian. So in this case, quotation from the judge or from the court, in the construction, interpretation of contract, the court is not bound by the label. I mean, the court doesn't care about the label here, okay, that the parties choose to affix. But what's the duty of the court? The court will try to construe, to interpret the document as a whole, and the court will determine from the language lah, okay, or whatever evidence here, the court will see what's the nature, what the purpose, okay, what's the aim, okay, of the parties in entering into such an agreement. So having said so, we have a case here. I mean, this is the full, no, another case. Lim Hong Lian. Okay, just now, Xiao Xiu Hong, Lim Gin Qian. So I was confused. Lim Gin Qian. Now we have Lim Hong Lian and Tan Kim Lan, 1997, High Court decision here. So in this case, plaintiff and defendant, they executed MOU lah. Okay. And then what's the reason? They anticipate to take over lah certain target companies. Okay. I mean, it relates to Companies Act as well. Okay. And then plaintiff later, he sought to enforce the terms of MOU against defendant, and he was claiming for compensation lah, okay, because he alleged, defendant breached this MOU. Now, the issue before the court, whether this MOU was a legally binding document or not, because generally MOU is lacks of intention kan, alright, but the court consider the totality of the terms lah, okay, and the court came to the conclusion, yes, the party did not intend to create legally binding contract based on MOU alone. Because why? There need to be various approval. I mean, it's not concluded yet, basically. It's not complete yet. There and then, okay? Needed to be obtained, and various uncertainties and the process of negotiation that needed to be carried out. So yes, MOU means what it is lah. MOU is just a mere memorandum of understanding. So they need to enter into specific agreements, okay? They need to obtain approval, okay? And then they need to go through whatever negotiation. So it's not really concluded yet. So MOU means MOU lah for this particular case. But then, compare with this one, okay? Just now, 1997. In year 2000, we have another case involving MOU. The case name is Ismail bin Muhammad Yunus and First Revenue. Okay, another case by High Court. Can you remember, for precedent basis, one High Court decision does not bind another High Court actually. I mean, High Court, that's why we have different judgment by one High Court and another High Court here. So in this Ismail bin Muhammad Yunus case, the court examined, okay, whatever MOU. There were two MOUs here, okay, but the court said, well, everything is so clear here. I mean, you cannot argue based on uncertainty to negate intention here. So these two documents, despite the label you attached to it as MOU, but it was, I mean, they were binding. And whatever uncertainty defense here, the court did not accept lah. Okay, raised by defendant must fail. So plaintiff won the case. I mean, MOU has necessary intention. I mean, different compared to earlier cases now. Okay, let's go to the final three letters for tonight. Letters of intent, letters of award, and letters of comfort. Okay, what is letter of intent? Usually the acronym is LOI. Okay, and then sometimes also it overlap with MOU or even MOA, Memorandum of Agreement. So LOI is agreement. I mean, is a document or a device. What's the purpose? To signal parties' agreement to the basic structure of a serious negotiations to close a deal. So it's like preparation lah still. Okay, I mean, it express your intention. That's why the name is letters of intent. I mean, expressive. Okay, expressing your intention. And normally, it is used in construction and engineering contract. Because what's the reason here? So that contractor can immediately commence their work on the site lah. Okay, because maybe they are waiting for specific contract to be signed, but pending those contract, there will be LOI lah issued. Okay, while they are anticipating a contract to be signed later. Okay, full formal contract cannot be executed by the parties. Maybe there are some problem. Okay, they are waiting for the contract to be executed, so they prepared LOI first. Then. Okay, and this is all the explanation lah. Alright, common practice to issue LOI to enable the selected contractor to start work. But then again, whether LOI here has intention. I mean, can you sue based on LOI alone here? Does it have necessary intention or not for LOI? So there's no clear-cut rule here. Okay, sometimes problematic and it is subject to dispute lah. Alright, but generally, okay, in this case, in Turif construction, this is one of the leading case lah pertaining to letters of intent. You might come across this case, but this is a common law, 1971. In this case, the judge, the name is Fay, okay, Judge Fay, he said that generally, okay, is just expression of your intention. So it's not binding, basically. Okay, for letters of intent. The names describe lah your intention, but not really a contract. But for the case of British Steel, okay, judgment by Court of Appeal, the court come up with different observation lah. Okay, but then the court look at all the text here. You can read the facts later. Okay, it is there. This is the summary lah. Involve two parties here, contractor, and then certain duties okay, on the part of the parties here. Alright. But the court said, well, for this particular case, okay, I mean, the court didn't apply Turif just now, but the court said for British Steel, there's a contract already. Okay, despite that they use letter of intent. Yeah, I mean, everything was so clear. I mean, it was a normal contract. Alright. So after all, the court said, well, everything must depend on the circumstances of the particular case. So for this case, everything is so clear. Despite that, letters of intent was being used as basis of argument. Okay, for British Steel Corporation. Okay, we move to the next letter. I mean, it relates to intention as well. Letter of award. Okay, what is letter of award? I mean, not the award that you see on TV kan, dapat award, okay, or gala award, okay, whatsoever. Here, letter of award here, it means you have been successful and you get a contract lah. Okay, so you get this letter before you have actual contract. Okay, so the aim of the letter is to give the successful bidder, usually pertaining to bidding lah, bid kan. You success, I mean you got the bid. Okay, here. So it's just a mere reassurance lah. Okay, and then to allow them to begin preparation so that the party can do whatever necessary preparation, okay? And then refraining from any commitments to legally binding obligation. I mean, the one who is supposed to give the award, they retain their rights to change actually. That's why they don't sign the contract yet, okay? But they just prepare letter of award first, okay? So what's the rule here? Is it binding? Generally, no. I mean, still a lack of intention, similar to letter of intent just now. But then again, it depends on the specific facts lah here. Because why? The main function of letter of award here, LOA, it opens the door to proceed to discussion. I mean, there could be some more discussion lah, okay, or clarification on the details of that result in the actual contract. I mean, they wanted, I mean, it's for the purpose of having discussion so that they can come with actual contract, okay? But then in some of the cases involving letter of award here, for example, in the case of Self Infra, this is MLJ, local case by High Court. But for this case, despite the label attached letter of award, but it was a legally binding agreement already. Okay, despite the rule that, well, usually not binding. But for this case, everything was so clear. I mean, no need for further discussion or negotiation. So even though it's letter of award, but it's contract already, legally binding contract. So it has intention, okay, to create legal relations despite the term used as letter of award. Okay.
Dr. Suzy, my experience myself received the letter of award from the tribunal perumahan that asked the construction, I mean the developer pay to me. Okay,
but different purpose.
Oh, different. Letter award is that come across to the contract lah. It's not the letter award come from the any
the one who is supposed to give contract kan.
Yes. Okay.
For the payment kan. I mean the name will be similar tapi the effect will be different lah. Okay, the one that we're discussing.
Thank you.
Now we discuss in the context of intention, okay, to create legal relations. Alright, thank you for asking. So letter of award might be used in some other context as well lah. Okay, the word award tu very general actually. Okay, so that's why whenever the case is brought to the court, the effect of the letter of award, it could be persuasive. That's why the court might decide in favor of the one who is asking to enforce the agreement. Okay. So just now the case law kan, the facts lah. Okay, you can have a look later. Last, okay, for tonight, letter of comfort. Okay, as the name is used, okay, comfort, to give you comfort lah here. Alright, so it refers to a document, okay, given by usually for company lah, company we have parent company, we have subsidiary kan, parent subsidiary. So letter of comfort will be issued by parent company, okay, and then issued specifically to the bank, okay, pertaining to its subsidiary company in response to a loan given by the bank. I mean, loan given to subsidiary by the bank. So now parent company issued letter of comfort. All right. And then what's the reason here? What's the aim? Offering some form of comfort that the parent company will ensure subsidiary is able to repay the loan. That's the purpose of letter of comfort. So in terms of content, okay, letter of comfort normally includes statement of awareness, commitment to maintain ownership interest, and degree of support. But again, I mean, it doesn't create a binding responsibility on the part of parent company here. Alright, the rule here is not, I mean, it's not equivalent to guarantee because guarantee is specific type of contract. I mean, if you are the guarantor, I mean, the moment default on the part of subsidiary, the parent company will be paying kan, alright? But for letter of comfort, no. It doesn't give rise to such a commitment or legal obligation lah. Alright, so in the case of, this is Court of Appeal, okay, England. So Clearwood Benson, the court clearly stated, letters of comfort had no contractual status and were unenforceable by lenders. I mean, just to give you comfort. But then, if there is any problem later, you cannot sue based on letters of comfort alone. Okay. And this is some of the position of law in other jurisdiction. Okay. In Australia, it depends on how it's being worded lah, in order to say whether we can make you liable or not here. Okay, if it is a strongly worded letters, so it might impose legal liability. Okay, but for English, I mean New Zealand and England, so I mean they are, I mean a different approach compared to Australia. So Australia said, well, it depends on the wording, but for England and New Zealand, no, usually for letters of comfort, we don't impose any legal liability as. All right, and then last but not least, this is an example of letter of comfort. Okay, if you Google, so you might come across this example. I mean, the wordings used, especially here. Okay, we hereby confirm and we confirm. Okay, and then it's our policy to ensure that the business here, in the position to meet its liability. We'll try to make sure. Okay, on our part, on parent company parts lah here. All right, and this is for. I mean, if you want to read, this is some of your reading task lah, okay. Baldah Tayyibah, because for the case of Baldah Tayyibah, quite recent, 2020, quite long, 25 pages. It covers offer acceptance lah, okay, consensus ad idem. It covers subject to contract. It covers letters of intent, MOU, letter of award, and JV agreement. So if you read, it could be useful lah. You can see, oh, this all discussion pertaining to the subtopic just now. And we also have the case of 2014, Tan Hong Sang and Tan Hong Kim. This one, ITCLR2, intention to create legal relations between father and son. So it could be, I mean, it is relevant for our topic tonight lah, for this case. This is High Court decision. So we conclude, I mean, I stop share. And I think I stop record lah kan. Stop